Good morning and welcome to the Institute for Security Studies. My name is Gugu. I will be your chair for today's seminar. I'm a researcher. I work under the Transnational Threats and International Crime program. Today we'll be launching a monograph on the use of less lethal weapons in South Africa. The launch of the monograph has come at a very crucial time in South Africa, where the use of such weapons has been a topical issue in the media. The first part of the seminar will be broadcast online until the end of the formal presentations, after which we'll go offline and have our discussion under Chatham House rules, giving you, the audience, an opportunity to ask our panelists some questions. We'd also really like to thank our online audience for joining us today. I hope you enjoy the seminar and the fruitful discussions. We would also like to thank our funders, the European Union's European Instrument for Democracy and Human Rights. Our implementing partners are Justicia Global, based in Brazil, the Legal Resources Center, based in South Africa, and the Amiga Research Foundation, based in the UK. We believe that this is a critical discussion, also given the shooting of a South African actor, Patrick Shire, that highlights the risk posed by less lethal weapons used in the policing of protests and prisons in South Africa. We will be discussing the evidence and abuse of these weapons, laws and procedures governing their use, effectiveness and accountability measures, and how to strengthen control over their use. Our first speaker is Mr. David Bruce, who is the author of the monograph. He is a writer and researcher specializing in the field of policing, criminal justice, public security, corruption, violence and crime in South Africa. The format of the seminar will be conversational in nature. Since 2011, David has worked as an independent researcher, primarily on contract for organizations based in South Africa and within the NGO sector. David will be sharing some key highlights of the monograph with us. We'd also like to thank David for the extensive research that he's put into this monograph. A lot of research and time has gone into it and dedication, and we applaud you for that. I'll hand you over to David.
Thank you. So I can just stay here, is that right?
Yes.
Yes, okay. So good morning, everyone, and good morning to my fellow panelists, and thanks to the ISS and my other partners for hosting this event and for giving me the opportunity to write this monograph and to present here about it. So my job today is in many ways to introduce the monograph, and the monograph is quite, in some ways, quite intricate. It deals with the use of less lethal weapons in two state organizations in South Africa, one being the South African Police Service, the other one being the Department of Correctional Services. And so within the SAPS, it's specifically focused on the public order domain. In DCS, it also looks briefly at the private prison context, but it covers quite a range of different weapons, including rubber rounds, stun grenades, batons, water cannons, and so on. And it also looks at different issues relating to these weapons, including evidence regarding their use, evidence regarding misuse of these weapons, information about the regulatory framework and about accountability measures in relation to the public order policing and the correctional services terrain pertaining to the use of these weapons. So, as a way of trying to make the kind of presentation more tangible, rather than going into the intricacies of all of this, I'm just going to be focusing on one aspect of this, which is the use of rubber bullets in the public order policing terrain. So now, rubber bullets are, I think I can say with some confidence that they're the most widely used less lethal weapon in public order policing in South Africa. And just also, it's worth observing that internationally, there's a wide range of different types of projectiles sometimes referred to as rubber bullets, but sometimes under other names, which are used in a similar manner in public order policing. And so, due to the kind of diversity of projectiles that are used, many of them they include kind of plastic projectiles, there's a type of round called sponge round. Sometimes the rubber round themselves, might have, for instance, a metal cartridge in a rubber casing, and so on. So, in some ways, the term rubber bullet is not an appropriate term, collective term for all of these projectiles. And so the term that's used increasingly by people working in this field is the term kinetic impact projectiles, to talk about these different types of projectiles that are used. But anyway, in South Africa, the main kinetic impact projectile that is used is a type of rubber bullet, and I'm just going to be talking about rubber bullets in South Africa. So also it's also just worth reflecting that I'm not sure if this has been a really big year for protest in South Africa. There have been some notable protests. I think one of them that springs to mind is the violence against women protests that took place in Cape Town. But internationally, the last year, I think, has been one of a year that has been distinguished, I think, by many notable protests, including protests in Hong Kong, protests in France, protests, I think, in various South American countries, protests in Iraq. But the one protest that I then want to just refer to specifically in relation to the use of rubber bullets, and it's an interesting reference point, is the protests in Chile. And so there, the police use they were calling it a rubber round. It's a cartridge that holds 12. I was just communicating with people from Omega Research Foundation yesterday, and they said it's 12 or more pellets. They're supposed to be plastic pellets, but then just and these protests, really large-scale protests, started happening roughly about a month ago. I think it was early in October. Anyway, and there've been, really enormous protests, and there's been very large-scale use of these projectiles by police in Chile, and so one of the things that then happened was that people started raising questions about the use of these projectiles. And there was a study then conducted by the University of Chile into the composition of the projectiles. And what they then established was that only about 20% of the material that was used in the projectiles was rubber, and that there were a range of other materials, including lead. And so they were a type of a kind of pellet that was being used by police that had some lead, some rubber in it. And one of the facets then of the protests in Chile has been in the region of between 200 and 300 people who've had traumatic eye injuries. I'm not quite sure if there's a statistic on the number of people who have suffered kind of permanent damage to their eyes and so on. But one of the facets of the use of these weapons is the risk of eye injury. And so just if we talk about the use of these weapons in rubber bullets in South Africa, it's something that's not widely known, but at least one of the people who was... We often tend to focus on these weapons when there's, for instance, a fatality. Insofar as there's news coverage of the use of the weapons, it's often related to, someone was killed. But in many ways, the most, let's call it kind of pervasive harm that is done by these types of weapons are types of non-lethal injuries. And the one type of injury of that kind would be, injuries to people's eyes or blindness. And so, at least in the in the Fees Must Fall protest in Wits, October 2016, there was at least, the person was actually an office cleaner who worked in the Braamfontein area and was on the street at the time where police were engaged in some kind of confrontation with students, and was injured by a rubber round and suffered a loss of permanent damage to one of his eyes. So, okay, so then just if we're talking about the rubber rounds that are used in South Africa, what is the standard issue rubber round in South Africa is a cartridge which has two small rubber balls. They're bigger than the rounds in Chile. Those, I think, are about 8 millimeters in diameter. These, I would guess, are maybe something like 20 millimeters in diameter. And anyway, there's two initial observations that one can make about these rounds. The one thing is that aerodynamically, a round projectile is a ballistically unstable projectile. It's difficult to fire it with any accuracy. But the other thing is that these are, they don't have 12 balls, they only have 2 balls, but nevertheless, they're multiple projectile rounds. And also then multiple projectile rounds are by their nature inaccurate. So now what I want to do is just, for the purposes of this presentation, I'm just going to call them old generation and new generation approaches to crowd management, crowd control, and the use of force in crowd control. And so I think to some degree what one could say is that in the past there was more acceptance of the idea that when one was used force against a crowd, one might use force in a fairly kind of undifferentiated way. One might fire rubber rounds or use other weapons against the crowd, and insofar as one had reached a point where one was going to use force, one would potentially, anyone who was then part of that crowd would be regarded as a legitimate target of that use of force. And so if one looks at these kind of type of multiple projectile rounds that are in use in Chile and in South Africa, it would appear that they are actually designed for that kind of use. They aren't designed with a view to having a high level of accuracy. They're designed on the basis that they will kind of disperse as they, unless they fire at someone at very short range. And they will potentially hit more than one person at any one time. So now, one problem with this type of approach is that I think I won't be going out on a limb if I say that it's actually illegal in South Africa. So if one looks at the kind of general principles that apply in relation to the use of force, principles of necessity, proportionality, and reasonableness, shooting a projectile at a person who is not themselves acting in a violent manner is, at least I would think that there would be quite a strong legal argument that is unjustified. Also then, in South Africa, in the Constitutional Court in 2012, there's a short quote from a judgment in the matter of Sitawu versus Garvas, in which the court basically said that people who are protesting, where there are people who are engaged in violence during the course of a protest, it doesn't deprive other people who are present at that protest and who are protesting peacefully of their right to protest. And so basically then one can say that in South Africa people have a right not to be shot by police when they are protesting peacefully. So then if we're talking about what one might call a kind of new generation type of approach, which is, as far as I understand, what is increasingly accepted, notably in Western countries, and I'm not quite sure what the legal position is in, for instance, South American countries, or for instance, in Hong Kong. but that essentially that in situations of protest, the police needs to attempt to adhere to the principle of differentiation, at least in the way that they need to try and ensure that the manner in which they use force is selective, that they're targeting the use of force at individuals whose conduct is violent or in some other possible way specifically justifies the use of force against them. And so it's just that's a kind of trends partly based on human rights principles, but it's also based on current what one could call contemporary crowd control theory, and so which in terms of which the reasoning would be that it is counterproductive in terms of police crowd control techniques. Crowds are not homogeneous, and effective management of crowds requires optimizing cooperation between police and crowd members. When police do not target the use of force at individual violent protesters, but instead shoot members of a crowd indiscriminately with rubber bullets, they unify the crowd in antagonism towards them. So then, if we just, having a conversation about rubber bullets for the moment, there's other issues that emerge in South Africa. The one thing is that emerges for me from the research that I was involved in for this report is what one might call a small irony. The regulatory framework pertaining to the Department of Correctional Services also allows for the use of rubber rounds by Department of Correctional Services officials in situations in prisons where the use of force is justified. And in fact, in the Correctional Services Act, there are provisions applying to the use of rubber rounds by DCS officials. The irony of it comes in relation to the fact that rubber rounds are very little used in prisons. The people who use them most extensively are SAPS, Public Order Police. But the regulatory framework pertaining to the single regulatory provision of the national instruction governing public order policing pertaining to rubber rounds is, an extremely vague provision, which basically refers to extreme circumstances and says nothing else. So, insofar as one would want to have, specifically training provisions, but also, I think, for instance, in some police departments, they treat these more as types of guidelines rather than necessarily always being strict regulatory provisions. These are standards that you need to try and comply with. We understand that crowd control situations are often very unstable, that it is necessary to adhere to certain kinds of standards. But the kind of issues that would be addressed in a more comprehensive regulatory framework would include the types of circumstances where the use of rubber rounds should be authorized, that police should avoid injury to bystanders and protesters whose individual conduct does not justify the use of force against them, emphasizing that rubber rounds or other kinetic impact projectiles should not be used at short range, including specifying a distance that qualifies at short range. And potentially there would be exception to that in that it might be justified to use them at short range in circumstances where the use of lethal force would be justified. Specify also how kinetic impact projectiles should be targeted, taking into account their likely accuracy or inaccuracy. In the United Kingdom, for instance, the belt buckle is used as an aim point because the trajectory of the projectile causes it to fall off over the range, impacting on the lower limbs. In France, police are instructed to target the torso and limbs. And finally also, but not least important, the need to ensure that those who are particularly vulnerable, such as young children, elderly people, pregnant women, and the disabled, are not targeted. Okay, so then moving on from rubber bullets, as I've already made note of, the monograph talks about a wide range of different types of weapons that are used in public order policing and in the correctional services environment. As I've noted, they include tear gas, stun grenades, water cannons. The SAPS has also now procured 40 long-range acoustic devices. They now say that these are to be used exclusively as communication tools, though initially when they procured them, it is clear that they were intended for use as a less lethal weapon. But as with, even more so than is the case with rubber arms, there are no regulatory provisions in place which specify how they may or may not be used. So likewise also then the monograph also focuses on the less lethal weapons that are provided in the prison's context, and there it would appear that the weapon that is most widely used is the baton, probably the tonfa baton. But the issue that emerges as the strongest, as the biggest concern in the prison context is an electric stun shield, which has been used quite extensively by the emergency response unit in the Department of Correctional Services. And the way in which it is used often amounts to, has in some cases amounted to the use of this shield as an instrument of torture. And the monograph suggests or motivates that due to the high risk that this type of electronic weapon, of it being used as an instrument of torture, it should be prohibited for use in the correctional services environment. So then just if one talks about any of these weapons, one can have this conversation about what are the risks associated with the weapons, what evidence do we have about the use or misuse of these weapons. Are the weapons that are used compatible with the standards that should apply to the policing of protest or the management of correctional facilities in South Africa? Does the manner in which they are used support effective management of crowds and prisons? What are the types of standards or regulations in place? Are they clear? Are they reasonable? Do they address the issues that they should address? And then what type of accountability, if any, is there for how these weapons are used? So then just, if we can just talk about, one of the things that the monograph does is motivate for clearer, better, more comprehensive regulations. The interesting thing again is that in the public order policing context, the regulatory framework is essentially rudimentary in the extreme. The Department of Correctional Services regulatory framework goes in the kind of opposite direction because it's quite intricate, and in some ways internally contradictory in some places, and internally incoherent, and things like that. So that's the type of problem there. So one would want a a more coherent and potentially a kind of a more integrated regulatory framework in the DCS environment. But you know, the question when one talks about improvements in the regulatory framework, the question that inevitably raises is about accountability, because the evidence is that, and I'm talking specifically about the public order policing environment here, that there is not effective accountability for misuses of force in the public order policing terrain in South Africa. So I think if you focus, you know, there are occasionally incidents which have received public attention relating to what appears to be the misuse of force by members of public order policing units. In the one case, the Andries Tutana case, 7 POP members were actually put on trial, though they were acquitted. But and so one could go into why they were acquitted. It comes down to issues of identifying members of, even though in that case the use of force was caught on video footage, the court could not link any one of the individuals involved who was put on trial to the use of force and therefore to Tutani's death. And so so a broad issue across the public order policing terrain is that misuses of force in public order policing very rarely translate into any type of complaint against the police, but even if they do, they're highly unlikely to translate into any type of disciplinary or other sanction against the police member. And so just then, you know, by way of wrapping up, I want to return to this point, which is that in some ways the kind of reflex in South Africa is that to focus on these weapons insofar as they are linked to fatalities. But in many ways, what we need to integrate into our discussion about these weapons is that they are associated with a different type of injury, a different type of use of force, a different type of harm. And so the one illustration of it is the wide range of kind of eye injuries that have been suffered by afflicted people in Chile, and there's evidence in many other countries and in South Africa of eye injuries related to the use of these projectiles. There is also, it's not that I want to downplay the risk of fatalities. The one high risk of fatalities is, for instance, with young children. In the last 30 months or so, 2 infants have been killed by the use of tear gas in public order policing in South Africa. And so also then, you know, one of a few of the people who've been killed from the use of rubber rounds in South Africa have also been young children. For instance, an 11-year-old boy who was killed a couple of years ago. And I think I'm just going to leave it there. Thank you.
Thank you so much, David, for that, and thank you for providing us with a broad overview not only of the use of these weapons in South Africa and globally, and the challenges associated with the specific type of these weapons and their techniques. I find that what is of great concern is the aspect of these weapons being used as tools of torture, and that there's a great need for the regulation of these weapons. And this shows that there are gaps even within our legal frameworks in South Africa. I'll now hand you over to Umesh, who has worked for the Judicial Inspectorate of Correctional Services for almost 20 years and has a great legal background. He's a graduate from UWC, and his interests lie in criminal justice, and he's an expert within this field. He's currently the head of the Subdirectorate of Complaints and Mandatory Reports, and he also heads up the other subdirectorate, being Inspections and Investigations. I'll hand you over to Mesh then if you have some comments from David in terms of public order policing and your experience within the work in prisons.
Thank you. Good afternoon, everyone. Thank you, David, for entering the arena of the correctional environment. The Judicial Inspectorate for the Uninformed has been around since 1998. It's headed by an inspecting judge, and its core functions are to provide an oversight function over the Department of Correctional Services. And essentially, the current legislation is confined to the inspectorate being a reporting body to the President, to the Minister, and to the Portfolio Committee. I mention that because currently, David hasn't mentioned too much on prisons, so I thought I'll just use the opportunity just to expand your knowledge of our experience. There is a current debate, and to those who are interested, on the Judicial Inspectorate's relationship with the department. Besides its functional and operational day-to-day oversight, there's a debate on our independence. Let me call it JICS, right? It's Judicial Inspectorate for Correctional Services. The acronym is JICS. So there is a very interesting debate which culminated in the High Court of the Western Cape, in September of this year, in which certain provisions of the Correctional Services Act were declared constitutionally invalid. The confirmation has to obviously take place in terms of that, the normal process to the Constitutional Court. But to those who are interested, the judgment will make very interesting reading on the day-to-day frustrations that the Judicial Inspectorate experiences, which obviously speak to the broader issues of whether we are structurally correctly placed within the paradigm of the department being responsible for our finances, etc. But one of the debates that's currently taking place, and I want to latch on to this, the question of accountability, extremely important. But before we get to accountability, I just want to touch very, very briefly on the current legislative scenario is that the Judicial Inspectorate, as I've said, is a reporting body. So we inspect, we investigate, we deal with inmate complaints, and on the topic today, we also look at the incidences of deaths caused from unnatural causes and or assaults. Now, this is another debate maybe for another time, but I think it's important to state this is there are lots of thoughts with regard to how in the range of powers we have is to inquire, to ask, to make findings, and to recommend. Should we have final and binding powers? For example, that's something that for those who are interested is something to think about. There are two views. One, you give an institution like ours similar powers to the public protector. Of course, it's a different set of facts in that case. But if you say final and binding, what are the consequences of that? It's a good power to have, but then the challenge would be that it has to be definitive. Our staffing would have to increase multifold. At this stage, we're a fairly small organization with, give or take, about 100 staff, including administrative staff, etc. But insofar as the current accountability, while I'm on that topic, in respect of harm caused to inmates resulting in death and or injury. And the monograph speaks about it. I will talk about two very briefly, and again, I think it will be interesting to see what the outcome is. Let me first say that I think it's common cause that few and far in between are the Department of Correctional Services officials criminally charged and or open inquests, formal inquests are held, and if they're held, whether they time use or not, there's a debate. We have a particular view, and I'll mention two cases which we look forward to the outcome. At the Brunfley Correctional Centre in the Western Cape, it's a maximum security prison. Inmates with long sentences incarcerated there. There is a high incidence of gang and gang-related activity. In 2015, sometime in January, and I think David does mention that in the monograph, there was an incident which resulted in the death of an inmate. Briefly, the facts are that an inmate who was alleged to be a gangster, and I think we can agree that he was a gangster, had attacked an official or a warder. Subsequent to that, and over a period of time, and we touch on torture, as everybody would know, that torture, the intensity and gravity of the attack, and over time, for particular purposes, is defined in terms of our Torture Act. This particular case had resulted in the death. And amongst the weapons used, David and colleagues, it started with the stabbing of an inmate of an official. Then batons were used, and we'll talk about batons, and there's a conventional way to use a baton, and there's a particular set of circumstances that must exist. A Rottweiler dog was used in this process. I believe, I'm subject to correction, I believe tear gas was used. So it was a free-for-all at a stage. One can understand, and we have a context with regard to it. Inmate stabs official has to defend him or herself. It's in a confined area, there are other inmates, so the presence or imminence of an attack is real, is there. But of course the test is again objective. This particular story was videotaped, this incident was videotaped by the Department of Correctional Services. There was sufficient evidence in our view that the brutality of the attack, the intensity of the attack, there was no proportionality. When at a particular stage that the threat had subsided, it continued. And I believe this is on public record. So what had happened, there was a finding by the Department of Correctional Services initially. And I want to talk about what we feel is another debate within the department with regard to, they're not easy jobs, they're intense, there's psychological effects on inmates, but part of what had come out from the department was that they highly stressed difficult circumstances, and at times they do that. Now, of course, those are mitigatory factors rather than preceding a finding of liability, criminal liability and civil liability. We, the inspecting judge, the current inspecting judge, Johan van der Westhuizen, had looked at it when he took office and then approached the department and said, look, your conclusions are that the inmate should be exonerated for the reason that the stressful circumstances, etc. We then took it on review internally. There was a fresh investigation, and of course logic would have it that it had to be changed. We were happy to the extent that consequences did follow, that officials were charged internally. It's another aspect we looked at. And that matter is currently in a court. This is what I want to say. So we've pursued that. It has not been the policy for us to vigorously pursue criminal prosecutions because of our power, but we always expect South African Police Services and or the NPA to prosecute. We are told by the DPP in the Western Cape that those inmates would be charged. To conclude what I want to say with regard to the accountability mechanism, that a culture of impunity, of course, is going to exist and is going to permeate if few and far prosecutions take place of public officials who exercise public power. As I said earlier, that I think it's common cause that very, very few take place because of a lack of resources, perhaps a lack of will, perhaps a relationship, maybe not overt, between police and the department with regard to wanting to prosecute those cases. That's the one interesting matter of when I say interesting, something that all of us who wish to take note, and we'd see how that pans out. In another matter, and I'm veering a little bit off because it's true what David has said, rubber bullets are used few and far in between in a correctional environment. But I'll talk about the baton right now. But while I have a bit of time, I'll talk about another matter and looking at the process of the criminal justice system that needs to complement what Chicks finds. In 2009, there was the death of an inmate. It's mentioned here at the South Africa's only closed or supermax prison. It's called Ebongweni. It's in the KwaZulu-Natal province, and it's similar to similar prisons in the United States. 23, 22 hours locked up in a cell. If you leave the cell, you are handcuffed. You shower in a confined area and or cage, etc. So, and of course, it's another debate with regard to its justification, whether what their prison regime, whether it's suitable, whether human dignity is high up on the criteria or principles with regard to the incarceration. But what had happened to this person, I'll give him initials, RT, Mr. RT, was beaten to his death. 2009. We had obviously investigated the matter. We did investigate the matter. We became aware later that there was a dispute between two pathologists. So the state pathologist had indicated that the cause of death, I believe it was multiple injuries, soft tissue injury and all of those kind of things. Then the family had appointed a private pathologist. That pathologist had indicated that there, besides the multiple wounds on the body, that his conclusion was that it appeared that the person was suffocated. So they did, I think, what pathologists talk about, a flap. They take the skin off, and you could see compression marks. So we currently that matter. Let me just. There was an inquest, and it's something that we've asked the National Director of Public Prosecutions to look at, because the inquest had found there was no prosecution, of course, and as you know the law, if you don't prosecute, you've got to have an inquest in terms of the Inquest Act. The inquest magistrate, sometime in 2013 or 14, so death took place in 2009, 13, 14, I believe. An inquest had found that they could not identify any particular persons. So the death was from unnatural causes, due to blunt force or multiple injuries. But what we had found when we looked at the inquest record, or the inquest findings, what they call a J56, that a formal inquest was not held. In other words, it was done on paper, and a finding was made. We have some other grounds that we think should be reviewed, whether that particular magistrate had not followed the DPP's request to have a formal inquest. Now, and a formal inquest, again, with regard to the accountability mechanism, would, if you know, I mean, there are many cases, apartheid related, the recent Timor inquest, would say, would tell you that in this particular case, two pathologist reports, two different views, and if you don't inquire into it in a little more inquisitorial way, it's almost, there's a lack of logic in just doing it on paper. That's one of the grounds of review that we want have done. Here the weapons, if I remember correctly, mainly batons, I think fists and boots and all of those kind of things. So they're not defined, but it's that kind of violence that had taken place. Two cases. So, David, thanks. We speak about one of the contentions we make, and one of the first things our current inspecting judge had done was ask how many prosecutions, whether the South African Police Services have enough resources to look at what happens in prison and what are those outcomes. So I've already said few and far in between prosecutions in terms of the Torture Act. That's something that we could debate. It's some of the matters in the monograph, if you read it, you'd probably think, I wonder what happened to this case. And we can talk about that in another time. Unless there's anything more specific, let me talk about the baton. Or let me just give you a general scenario. In many matters that end up in death and or serious assault between an official, and of course there's violence, intra-violence between inmates, but let's just talk about the public official vis-a-vis the inmate. There is a common thread, and that's usually there is a threat in the cases I'm talking about, the few. The threat is, in our view on the evidence, dissipated, does not exist, and then there is retribution. There are many colloquial ways in the prison context in which they talk about it in an Afrikaans way, and without using the rough words, maar ons sal vir jou kry. And there's an informal process of justice. If you spoke to an official, he'll say, look, it's hard, it's difficult, and that's one of the ways we control what happens there. I give it to you anecdotally, but I think it's common cause and logical to say, that's one of the ways you do it. And that's the other aspect which, as I said, the Brandvlei incident, and we had a seminar, by the way, sometime in the Western Cape, where the judge had presented the evidence. It was called Blood on the Floor. We had spoken about it, and if there's a mindset that needs to be changed, that's one of them. As I remember, I said to you that the initial decision was that I can't find any guilt, and the rationale was stressful. It had changed, which is good. A criminologist, I believe, or a clinical psychologist, I can't remember, it's some time ago, had also supported the DCS version. We were fairly aghast at that kind of expertise. And of course, we also had indicated that we can't continue this kind of paradigm where we understand frustration, stress, but then it results in this kind of situation. And because the person is a gangster, well, of course, that's not on wherever you are in our constitutional democracy. Let me just touch on, well, so the general situation is there are serious situations, inmates locking themselves up and barricading themselves. The officials can't get access. In fact, there was a particular case in St. Albans in the Eastern Cape, Port Elizabeth. Again, it's not an easy prison because, of course, of overcrowding. There's a high incidence of gang and gang-related activity. And I believe, and I'll accept that when a Department of Correctional Services official says, what do we have? We have a baton, we have a key, we can herd people into cells, but the making of weapons and all of those things in a cell, they happen, and the threat of danger and loss of life of an official is real in some of those prisons. But in the St. Albans matter, I believe in that particular case, if I remember the facts correctly, a rubber bullet was used, projectile. Very briefly, and one can look at it, I think it was in 2016, there were 3 deaths. So there was a situation, there was a stabbing, the inmates had then went on a bit of a rampage in the administration block, and then David has just touched on this emergency support team. It's called the EST. Now they are a special team when there are serious situations, hostage situations, serious violence. They come in, and their level of training and skill is something else we can also talk about. Their level of training and skill is a little more enhanced than the ordinary official, the custodial official. What had happened in this particular case was that in order to get the situation, I'll use the department's words, to calm the situation or to restore good order and security, a rubber bullet was fired by the EST. That's what the autopsy had said. The circumstances, of course, again, with regard to this matter going to the courts and or the inquest, we don't have an outcome yet, and that's the forum to get this out where, as I said, our recommendations can be tested and the departments can be tested. So batons, tear gas, the inmates had retaliated with fire extinguishers, etc. Now, we accept those are serious situations. But again, when we do this assessment is whether it was necessary, proportional. And I think, David, you mentioned something very, very important, is the day-to-day management of a prison and how that relationship takes place. Sure, an inmate who has a violent streak and is a habitual criminal and he's got life is unlikely, and it happens, but they don't even talk to us if we ask to want to adhere to any rules. But somehow, and I think it's a difficult person-to-person thing, and the type of psychology and training correctional officials should have, can't we avert these kind of problems? They have a formal structure where inmates can gather as a committee and discuss things that lead to frustration. In some cases it works, in some cases not. Again, there are examples of that. But I think it's something if we'd associate ourselves with, is that on a general level, skill, training, the person of the correctional official needs to be cared for, looked after, level of maturity, etc. When there are these, and remember in the prison situation, as opposed to maybe public order policing, they take place in confined spaces. It's all in this little space. There's lots of tension. And we often say, can you avert it? Could you have walked away? Could you have used less lethal weapon? They're often difficult cases. And on paper, maybe they're not the ideal way to do it. So that's what I was talking about. Prosecutions and or inquests where these things can be come out and justice can be done and be seek to be done. You talk about batons, David, you're right. That batons, tonfas, are the most common instruments used. That's what they do have. If you use anything more than that, you'd need particular permissions and all of those kind of things. But of course, in the more serious cases, there's a conventional way to use a baton, which you hold here and to as a defensive instrument. But often it's turned around and you are beaten. There are examples of being beaten under the feet. There are examples of delaying the medical assessment of the person, etc. That probably, maybe I should conclude, and stun shields, David had mentioned, yes. And whether it's an instrument of David, you if I heard you correctly, whether they should be prohibited in its entirety, I think we can continue that debate. If a Department of Correctional Services official had been here and say, look, when there are serious crowd situations or you're trying to enter a cell where a murder had taken place and you want to get in, you would need some form of protection as well. But it's an interesting thing, and I think, of course, this is the monograph ignites a discussion, and time doesn't allow for us to get into it more deeply. The last thing, I think I should sum up. The regulatory framework, the department, as I think you've acknowledged, has rules. Besides the Act and the regulations, they are called the B orders, which are really standard operating procedures. They are, I'm just looking at it, utilization of security equipment, it's set out and it's set out and it's set out. And that's good. We can look at a more stringent accountability for them and their use. But I think in a vacuum and theoretically, one can look at it. But I think if we take those examples, and of course at another time, or we can have a different debate with regard to how we change them, etc. I'm not going to enter into that debate. But I agree they can be looked at. I would prefer, if I had to express a personal opinion, is to take 1 or 2 or 3 test cases, test these things in the courts. And currently, Claire Ballard, I think some of you would know, Lawyers for Human Rights, who has a fairly long history and expertise in prison matters, currently litigating in the Johannesburg High Court in a matter called Smith versus the Minister and others. This is about an incident, as I understand, that occurred in 2014 at Leeuwkop in Johannesburg, where there are allegations of torture, systemic assaults, and the like. It's probably one of the cases, and I think Lawyers for Human Rights would say this, that as a test case, it could emanate, it could reveal lots of the court's thinking, let's put it that way. Sorry, I'm not saying that very elegantly, but because there are elements of torture. The pleadings talk about those were torturous acts. It'll be interesting to see that. And out of cases like that, one then gets a little more definitive idea as to what the general principles of accountability, a la Carmichael case and all these others with regard to the prison environment. I could go on, but I think I'll leave it there. Unless there's anything specific, I thought I'll take the opportunity just to expand on what David had written and give you some of my own perspectives. Thank you very much.
Okay, great. Thank you very much, Umesh. I really like that you touched on the aspect of accountability within the prison service, as well as highlighting the complexities of some of the issues within the Department of Correctional Services that I believe that some of us may not have been aware of. And I'd also like to thank you for talking about the use of force and the tools that have been used that you've highlighted, and also for guiding us through some of the recent cases that have been going on in South Africa over the past 5 years. I think that's something really critical, and David brings it up well in the monograph, where he looks at these some of these specific cases within the criminal justice system. So thank you for that, Nish. Okay, our next respondent is Dr. Thomas Probert. He heads up the Freedom from Violence program at the Center for Human Rights at the University of Pretoria, and he was previously a research consultant to the UN Special Rapporteur on Summary Executions, which was the basis for his involvement in the process, culminating in the United Nations Human Rights Guidance on less lethal weapons in law enforcement within this year. So Thomas will be providing us with an international overview of some of the instruments that are in place and some of the gaps that exist within this field. Thanks, Thomas.
Thank you, Gugu, and good morning, colleagues. I feel I need to begin with an apology in that I think some of you may have been lured here to ISS under the illusion that you were going to hear from Prof. Christoph Haynes, the former Special Rapporteur for whom I worked, who's been called to the Cape, unfortunately, and so can't be with us. Fortunately, having worked with him for a number of years, I've got used to that kind of disappointed look that I see on people's faces when this happens, so I won't take it personally. I'm asked to comment on the perspective offered by the UN guidance that David is so kind to highlight and endorse in the monograph. And I'll do that particularly with reference to the Assembly's context, as we've heard from the Correctional Services context just now. As a couple of background points on the monograph, I'm not sure whether people in the room have had the opportunity to read it yet. If not, I wholeheartedly endorse it. I think it's a fantastic piece of work. I think. As some background kind of points on it, one of its first strengths is highlighting the scale of the challenge that we face. Interestingly, in percentage terms, to dwell as I will on the Assembly's context, the monograph highlights how, at least in terms of reporting to IPID, that is in fact only really a very small minority of lethal incidents that we're responding to in the South African context. I think, David, something like 3% of the reported cases of fatality that IPID address. As you correctly highlight, I think only looking at fatalities masks the true reality of the situation, though the figures were similar for reported cases of assault. That, in a way, I think tells us two things. Firstly, that there is a significant problem that we're not going to be talking about today, which is the use of force by SAPs in other circumstances, what in the guidance we refer to as in the context of arrest, that kind of one-on-one encounter with a suspected criminal or member of the public, in which use of force takes place and fatalities arise. Less lethal weapons can play a role in that context as well, I think, importantly, and the guidance looks at the use of handheld chemical irritant, for example, sometimes there's pepper spray, the use of conducted electric weapons, commonly referred to as tasers, and the role that actually in a way, the greater use of some less lethal weapons in a South African context may lead to the reduction of that roughly 97% of cases that IPID looks at. But that's perhaps a conversation to take forward in the Q&A. The other observation I'd make about the monograph is that it includes, I think helpfully, a discussion about the use of firearms in the context of assemblies. Firearms, obviously, one might instinctively think doesn't belong in a conversation about less lethals, and it doesn't. But the use of firearms in the context of assemblies in South Africa, I think, is a very problematic issue, and I think giving it salience in this conversation is important. There are a number of sources now of international law, the African Commission's guidelines on policing assemblies, the guidance that I'll discuss, the new Human Rights Committee's at present draft general comment on peaceful assembly that highlight that firearms are not an appropriate tool for policing assemblies, and indeed in South Africa we face the even larger problem of the use of automatic firearms that I think we can say are inappropriate for law enforcement in general. And then the third background observation I'd make in applauding the monograph is the way in which it places this conversation of the practice of law enforcement within the legislative framework that SAPs operate. The section of the Criminal Procedure Act and the Regulation of Gatherings Act here in South Africa, but that as an example of a broader question that if we are looking, in my case as a representative of the human rights community, at the use of force by the police, that it is vital not only to think of this as a problem of rogue cops, but as a more structural problem of the legal framework in which these law enforcement officials are operating. And in the monograph, David highlights a number of concerns that we might have in the particular South African context. But I can say from a more global perspective that these are recurring problems. At the university, we've conducted an exercise in the last couple of years bringing together the legal frameworks with respect to the use of force in every country in the world, policinglaw.info, quick plug, where you can go and look at the law regarding the use of force by the police, the law regarding the use of force in custodial settings, and the law regarding oversight of both for every country in the world, which I think provides vital context to many of these conversations. So then the background for international guidance on less lethal weapons, which, as Gugu says, was launched at the Office of the High Commissioner for Human Rights earlier this year. The basic kind of starting place, I think, for most conversations about use of force, including David's monograph, the basic principles on the use of force and firearms by law enforcement officials. Now nearly 30 years old, still an incredibly useful resource and an important starting place. The basic principles call for the development of non-lethal, as it refers to it, non-lethal alternatives to firearms, but also specifies that such weapons ought to be evaluated and that their use should be controlled. So we have, from as far back as 1990, this kind of core international law enforcement document asserting that there is a real need to ensure that police officers are supplied with something kind of in the middle of this range from a police baton, with which most are routinely supplied, to a firearm at the other end of a spectrum with which in many countries around the world, again, most law enforcement officials are supplied. But the problem that I think the basic principles was alerting us to now a long time ago was that in many places we don't see law enforcement officials being supplied with something in the middle of this spectrum, and that's a problem. However, in those places that we do see them being supplied with it, we still have concerns that their use and broader, more policy considerations around how they're procured, how they're tested, how law enforcement officials are trained on their use, is insufficiently regulated. And so in several of his reports as Special Rapporteur, Prof. Haynes described the importance of forming some kind of international consensus around how this use ought to be regulated. From 2014 to 2016, we were involved in a process commissioned by the Human Rights Council to look at the proper management of assemblies, and this was an exercise in conjunction with another Special Rapporteur from Kenya, Maina Kiai, who was Special Rapporteur on Freedom of Assembly and Association, and between the two UN mandates we produced a report that David cites at various points throughout the monograph, providing these practical recommendations on management of assemblies, and there again stressed the importance of bringing together some kind of expert body that could move towards guidance on the policy area. The Human Rights Council, as I mentioned, had been passing resolutions on what it calls peaceful protest for a number of years, of which that report was part. Those resolutions in the way of the Council continue every 2 years. The most recent one in 2018 that specifically included language on less lethal weapons, calling calling on states to make available protective equipment and less lethal weapons in the language of the resolution in order to decrease their states' need to use weapons of any kind while pursuing regulation and protocols for training. And then in a technically coincidental but clearly related to the prevalence of the issue that we're facing, the Human Rights Committee, the body that supervises implementation of the International Covenant, is now in the process of adopting a general comment on peaceful assemblies that as well makes reference to the salience of the issue of less lethal weapons and refers to the guidance that has now been adopted. And so this a 2-year process was created to bring together the variety of stakeholders that I think we need to have in the room to have a conversation about this: states, law enforcement professionals themselves, civil society stakeholders, and manufacturers, critically, of the weapons to speak to those questions of design, testing, and how weapons are brought to market. That process involved a number of consultations, as I say, in Geneva, also one in Cambridge, one here in Pretoria, to which David made some valuable contributions, and ultimately produced a document that, as I said, was launched a few months ago in Geneva. The document itself is unfortunately yet to be printed with a kind of fancy UN cover so that I can show you the iconic image that you'll hopefully all come to know over the coming years, but hopefully that process will take place in the next couple of months. But the text is available on the OHCHR website if you want to consult it. It's quite a process driven document. I think it provides examples of good practice. It provides examples of what it refers to as potentially unlawful practice at the other end of the spectrum. But what it's really, I think, trying to endorse is the idea of a transparent process that begins with the way in which weapons are designed, the purposes that they're designed for, and moves through the processes that states undertake to procure weapons, to test their suitability for the particular context that they're going to be used in that national situation, the way in which law enforcement officials are trained on their use and made aware of specific risks that will apply to any weapon system, the things that make it particularly useful for a particular context will also lead to particular risks if it's used in a different context. And so ensuring that law enforcement officials are comprehensively trained on those risks before they are deployed with these weapons. And then the question of monitoring, that I think comes back to the observation about the IPID data and how few cases arising from protests in South Africa make it into IPID's numbers. I think that tells us something about what needs to take place with respect to monitoring other uses of force that don't result in death, but that are nonetheless, seriously worthy of attention. That needs to take place. So the guidance reasserts the basic international law principles around the use of force, the principles of legality, of precaution, necessity, proportionality, non-discrimination, and accountability. And then, as I say, goes through these various phases of design, testing, procurement, training, and monitoring. And it then moves into a set of specific sections on different weapons categories, ranging from the use of batons through handheld chemical irritants, a section on taser, a section on tear gas, on kinetic impact projectiles, on water cannon, and various other less lethal possibilities, including acoustic weapons that David, you mentioned at the end of your presentation. And in each case, it follows the same basic structure. It offers some observations about the design of these weapons, discusses circumstances in which they may potentially lawfully be used, highlights specific risk factors, the kind of risk factors that ought to then be included in training on that kind of weapon, and also provides examples of where their use would probably not be legal. Just to highlight the example, because David discussed rubber bullets, to look at the section on kinetic impact projectiles, I think two general observations that I'd make. On the circumstances of potentially lawful use, the threshold that the guidance establishes for the use of rubber bullets is the targeting of an individual who's posing an imminent threat of injury to law enforcement or to a member of the public. So it needs to be targeted at an individual, and then, as David says, also needs to be targeted at only a specific part of the individual, namely the lower body. And then, for that reason, in the section on uses that are likely to be unlawful, includes a standard on multiple projectiles launched, and David discussed the round that's used here in South Africa with its two elements that I think, reading the guidance, one would take to be unlawful. This idea that because the threshold for lawful use is that it's targeted at an individual, if you're firing a round that sends off two spherical and therefore highly inaccurate projectiles, it is unlikely that you are going to be able accurately to target a single individual. The guidance also provides a prescription on the use of rubber-coated metal rounds, which, David, you mentioned. I'm not sure, as a matter of fact, the extent that that type of round is used here in South Africa, but again, the guidance suggests that because of the undue risk of serious injury that such a round provides, that their use is likely unlawful. Also, on the multiple projectiles, David mentioned pellets. We've seen in various parts of the world, perhaps most infamously in recent years in Kashmir, the use of a variety of shotgun pellet being used for crowd management. That, again, reading the guidance, one would come to view as inherently unlawful. And so then, in addition to this discussion of specific weapon types, the guidance then discusses a number of areas in which less lethal weapons are used in terms of context of the use, as it were. And the three main ones being arrest, that I mentioned at the beginning, use in custodial settings, and then use in assemblies. And just to kind of highlight the key takeaways with respect to the use in assemblies, the guidance makes a number of observations. Firstly, that and David mentioned the kind of psychology of crowds and the non-physical impact that weaponry can have, that heavy displays of even less lethal weaponry may escalate crowd dynamics and make a de-escalatory approach more difficult. What you see as an example of good practice is often that police will prepare for the possibility of needing to use more extensive, less lethal options, but that they will strategically hide them in the next street or somewhere beyond the realm of public view, in order that while they're available if needed, they don't, by virtue of their presence, escalate a situation. And then, probably most importantly, this issue that David highlighted, the duty in an assembly to distinguish between individuals acting violently and others whose right to assemble remains unaffected by the fact that other people in the same gathering are acting non-peacefully. And that need to distinguish has clear implications in terms of the choice of weapon that you may use. The idea that dispersing an assembly really ought to be a last resort, and the use of less lethal weapons in order to disperse should be a last resort within the last resort, as it were. The idea that I mentioned earlier, that the use of firearms to disperse an assembly is always unlawful. That's a relatively clear standard of international law. It may be conceivable. Some police forces around the world take the view that it's not worth the risk of carrying firearms near an assembly. There may be a view that certain things can happen in the context of an assembly where the individual threshold for the use of a firearm may be met, and so law enforcement officials carry a firearm to an assembly, but the idea that they should be used to disperse an assembly is clearly a violation of international law. A comment, just because of the imagery that one sometimes sees of perhaps some of the most famous protest actions in this country around physical barriers and the use of barbed wire as a means of corralling crowds. Again, the guidance is fairly clear that poses an undue risk of injury, and that if barriers are going to be used, some alternative to barbed or razor wire ought to be used. And then it's a cross-cutting issue with respect to less lethals, but it applies perhaps in particularly significant ways in the context of an assembly. The access of medical personnel to those who have been affected by use of force. So, as I say, that's a general observation about how you train law enforcement officials with respect to less lethals. They need to be aware of the risks and also of the potential medical assistance that may be required in the aftermath of their use. If one thinks, for example, of the use of pepper spray by law enforcement officials, that they need to be trained not only on the risks of pepper spray, but also what to do with someone on whom they have used pepper spray after it's been effective and they've been able to regain control of the situation. In the case of assemblies, I think the access of medical personnel to parts of an assembly, moving through police cordons and this kind of thing, are considerations that need to be front and centre. So, in terms of concluding remarks, I think just to return to where I started, to applaud the monograph as both as an initiative in creating the opportunity to have this conversation, and in terms of the way that it does it. I think I wholeheartedly endorse the recommendations that it makes, including the spotlight that it casts on the need for certain targeted legal reform. But I suppose also not losing sight of the potential that less lethal weapons, if properly regulated, can provide to combat that broader 97% of cases of the use of lethal force. against people by the police in South Africa. But so if we're going to embrace the potential, we need to be conscious of the risks, including, as David says, not only the risks of fatalities, but the risks of a far broader range of harm. And that requires us to be vigilantly attentive to patterns of use. And so it takes us back to this theme that I think has cut through all of our presentations of the importance of accountability in this space.
Thank you so much for that, Thomas, and for also highlighting an international overview, especially looking at assemblies and crowd management. I also find it interesting that you did link up the aspect of looking at the trade and the production of these types of equipment that we are currently looking at, and hopefully will be ready to launch in February next year, because that's another important aspect, because these tools of torture that are used are not currently regulated in South Africa and are relatively easily accessible. So we still have 30 minutes to go and to wrap up this first session. We'd like to thank our online audience for joining us today, and we encourage you to download the Monograph. It is available online, and hopefully you can take these discussions within your respective environments or fields every day. So I'd like to thank you for that.